Phil Craig here from Domains and the Dollars, and I'm at the Miami Traffic Domain Name Seminar and Domain Name Auction. The auction's getting set up. It's going to happen here in an hour. But before we have the auction and I show you some of the auction that's taking place, I've asked Dr. John Berryhill, who is a very popular and effective attorney in the domain name industry, to appear here to talk a little bit about trademark law and the types of things that a beginning domainer might get in trouble with and what to stay away from. So thanks for showing up here.
Thank you. It's tough to be popular and effective at the same time. I'd say that I'm effective for some people and maybe a little less popular with some others.
Okay, of course. So, and that's something I want to talk about at the end, is if they're in trouble with some type of trademark issue, what you can do for them.
Surely.
But let's talk a little bit about trademark typos. And I know that there's been some reports that probably some of my viewers have seen that talk about getting a name that is a misspelling of some popular brand and then registering that name and then making revenue off that parked page. Now, is that something that my users might consider as a business, or is that something that is going to get them in trouble?
If your user's business is getting in trouble, that would be fine, but that is virtually the definition of cyber squatting. And the classical instance of that is a man named John Zuccarini, who is legendary for racking up court judgments for registering domain names like Electronics Boutique without the U, and targeting that toward electronic traffic. The law in the United States is that if you register a domain name that is identical or confusingly similar to a trademark with the specific bad faith intention to make a profit off of misdirected traffic to that trademark, you can be held liable for up to $100,000 per domain name, absent any other damages. It doesn't matter if you made $5 or $2, or even if you're at a net loss from that domain name. It's not a question of even what your profits were. The law allows a trademark owner to bring a case and to say, I don't even know what my actual damages are, but Judge, I would like you to award me up to $100,000 in damages. Now, the cases that have gone to decision are cases where defendants haven't shown up and have registered large numbers of egregiously bad domain names. So a judge, in considering an action under this law, the precedent that he has to look at are situations where previous judges have maxed out, and it's not something, and particularly a lot of domainers are young people. It's not something that you can blow off and say, well, I don't even have $100 in the bank. What do I care about a $100,000 judgment? Because a federal court judgment can be brought against you in another state. It can then be imported into your state. It will go on your credit record. It can follow you for the rest of your life. If you've ever thought about buying a car someday, getting a car loan, getting a mortgage, there are a number of things in life that even if you don't have $100,000 and consider yourself to be, judgment proof, having that judgment hanging over you can significantly influence the course of your life.
I mean, really, and so why bother? Why get involved? But let's say that before they heard us, they've done it, and now they receive that notice from somebody. What should they do? Okay.
Unfortunately, it can be very difficult for individual domain registrants to sort out these types of threats that come in. In fact, there was a man in Nevada that recently went to jail for pretending to be an attorney and for sending emails out to domain registrants in order to
Okay, so we're back. They turned the lights down on us, and so before they did that, we were in the middle of talking about the man in Nevada that got into trouble with sending out some notices.
Right. And, so it can be extremely difficult for a domain name registrant to, determine what is a valid claim or not. But that's not a reason for ignoring them. Now, look, I should back up a moment and say that prevention is certainly better than the cure. I think that if people have been, intentionally registering typographic variations of famous marks, you don't need to wait until you are notified by Microsoft that they have, trademark rights in Halo 3 and in Xbox, and if you're, selling Halo 3 Xbox modding chips.com, that's the kind of thing that Microsoft is going to be concerned about. Now, I'm sure after I say that, someone's going to look up and find out that Halo 3 Xbox modding chips.com is taken and used by somebody, and what other people are doing, it was never a good excuse in school when you were the only person singled out by the teacher. It also doesn't work at law to say that, well, other people are doing this, why can't I do it? Because if you look at cyber squatters as a herd and the trademark owners as the cheetahs, they're going to pounce on those particular antelope that they appear particularly tasty to them at any given time. So first, if one knows that one's traffic is coming primarily from trademark typos, you need to get rid of those. In the event that you receive correspondence on a domain and you've never heard of this trademark, or you're not sure of what the claims are, there are a number of domain name attorneys such as Ari Goldberger, Brett Lewis, Steve Lieberman, and myself, many of whom participate in domain forums, who offer free consultations. I probably look at anywhere from 10 to 30 cease and desist letters that I receive from different people every day, and I can tell you without obligation if it's a clear drop dead, yeah, absolutely, you're going to have to address this issue, or let you know if it would require some heavy lifting, if you're in a gray area, or if it's a clearly deficient claim in some sense. But these are judgments that you probably shouldn't be making for yourself without a legal background. Some people will look at, for example, the U.S. PTO, the U.S. Patent and Trademark Office has an online trademark database, but many people don't realize that there are a lot of things in that database that are not trademarks. They may be pending applications, they may be refused applications, they may be expired trademark registrations, and of course the most important thing that misconception that I see domainers having when they're trying to find out whether something is or is not a trademark is that it is not required for a trademark to be registered with the United States Patent and Trademark Office. When people say, well, what's the best trademark search system, I tell them the best trademark search system is Google. If somebody says, I have a trademark for X, Y, or Z, and you put that term into Google, and you get 3 pages, the first 3 pages of results are either their stuff or references to their stuff, then that's a good indication, a good initial indication, absent some other considerations if it's descriptive or generic, but it's a good indication that that they may very well have an enforceable right in that mark. And then, of course, clearly, if any of your readers or viewers are under the impression that this is a game that they want to play, it is a game that some people do play for a long time. But once you get caught, once you get burnt, and once once someone has latched onto you, it is becoming increasingly difficult for people who have gotten into cyber squatting situations to get their way out of it simply by saying, oh, okay, well, now that you've filed a lawsuit, you can have the domain name. Trademark owners are particularly tired of having to bother and pester and send repeated notices and then file a lawsuit only to have the guy surrender. And increasingly, they're looking for considerable amounts of money to simply to let you out. Because if they sense that they can get a default judgment for $100,000, why shouldn't they say, well, we'll let you go for $10,000, $15,000, $20,000 or more?
It's a serious game. And the thing about it is you don't need to play that game. But if you do, or if you have, and something comes up for you, John is available. You gotta get some legal advice. You just can't ignore the claim. Hey, thanks, John.
Sure thing.
For coming here and talking to him.
All right.
Really
Good luck.
appreciate it.
Be safe.
Yeah.